But soon after I was appointed as a judge of the Supreme Court, I quite realized that it's not just this formal division between senior counsel who don't file matters and the advocates on record who file matters. But really speaking, the whole institution of the advocates on record is so significant because it reflects two things. It reflects the diversity of India. It reflects professionals practicing before the Supreme Court who are truly in touch with clients, litigants all over the country. And in that sense, truly, professionals who are the pulse beat of what happens on the ground in our society. So many of you have appeared before me in the last 8.5 years, and I can almost I have a photographic memory, as my wife tells me. I can almost pick out the cases where you have appeared and you've conducted those cases with such a sense of commitment and drive. And I particularly enjoyed it when the seniors didn't appear. Because when the seniors appear in a case, you feel, with due respect, of course, to my distinguished brother, Justice Narasimha and Justice Vishwanathan. The good part about a senior appearing in a case is that you have a slightly greater degree of objectivity. The senior will not argue, or hopefully not argue, things which should not be argued. But when you have a senior appearing in a case, the difference between an advocate on record appearing in a case and a senior appearing in a case is that the advocate on record always treats the case as their own baby. For the senior, after all, it's that one appearance for that evening, or one conference in the evening and one appearance the next morning in court. Not so with the advocate on record. You'd so often find that the advocate on record perhaps sometimes takes things a little too far because you're so committed to the case, even if a case doesn't have that good arguable point. And I always felt this, and I never felt throughout my career that the advocate on record was stretching their luck beyond the point or stretching the case beyond the point, because there's always this perception that there is a human face behind every case. And it is that commitment to the cause of the human face which really, in that sense, unites both the advocates on record and the judges. Very often I have been asked as to why I listened so long to a case. Now I can let out the secret since I have only one more day and probably 45 cases, so you may not be able to use it too much to your advantage. 45 odd cases tomorrow. But one of the reasons why I listen so long to the advocates on record, and particularly in the juniors in the case, there are two reasons. One, I feel this is, after all, the court of last resort. Nothing really lies after the court says, all right, thank you, and dismiss. You, of course, get these bunches of review petitions and, curative petitions. Curative petitions are very often assessed, as I do, by who are giving the certificate. Some give certificates at random, some give them with greater deliberation. But one of the reasons why I thought, you must always hear the young counsel, particularly the advocates on record, is because this is the last point of recourse for the litigant. There is nothing hereafter that they can do. The second thing, and the second reason, which is perhaps more personal but more fundamental to me, is that I was always unsure, even after 8.5 years on the bench, on whether I had really grasped everything in the case. And the more you delve within your own heart and thoughts and mind, you're also conscious of your own limitations, both in terms of the acquisition of knowledge and in terms of the ability of the human mind to understand everything that there is in a relationship, whether it's a relationship between spouses, a relationship between partners, a relationship between corporates, a relationship between two levels of government. So you're always asking yourself that perhaps have I missed something? Would I have not missed something if I had heard that case for a little longer? But the one signal aspect of our bar which I find is the tremendous sense of faith which our advocates have, particularly the AORs have in the institution of the judges of this court. So very often you find that a case comes up with very high stakes. I had one case like that yesterday. And I then suggested a compromise to both the sets of, there were three factions actually, and I suggested a compromise. They virtually accepted that you dictate the compromise, and this would be acceptable to us. Now that's putting a very huge burden on the mind of the court, because while you suggest a compromise, you want parties to say no, because when they say no, then you can sort of negotiate with them and say that, well, all right, we'll try and work out something which you feel is appropriate. When lawyers say yes, then you feel that, my God, this is a huge burden that they have placed on me. So yesterday when I dictated the order in a very important commercial dispute, I said, I'm not going to sign the order. Take this order, sit with the court master in the court master's room. If you want any corrections, come today. If you find that you would need an extra day, come tomorrow and tell me what the correction should be. So they came back today and said, well, you wanted some corrections in some paragraphs, which we have now agreed to. So this shows really the intense faith which advocates on record have in the institution of the Supreme Court. So it's mutual. Our relationship is mutual. We have that sense of faith in advocates on record because we believe you represent the voice of the litigants. And we presume that you're not just post offices for somebody else's brief. Likewise, you have that sense of faith in us because you know that we listen to you patiently, conscious of the fact that you represent the voice of that small little individual for whom you are representing the cause of justice.